Hello, friends. Today we begin our journey into applied ethics by taking a look at some of the ethical problems that emerges in the clinical context, specifically related to patient-informed consent. So let's begin. It seems very intuitive for us today that we should respect a patient's autonomy or the right of self-determination. But because autonomous decision making is an ability, right? It's a capacity, as we talked about before, to actually do this is in practice is actually very difficult. The idea of informed consent seems to logically follow from the principle of respecting patient autonomy. But it is not until the 20th century that informed consent became a legal obligation of the medical profession. The principle of informed consent is one of the central concerns of what is called the Nuremberg Code, which grew out of the Nuremberg trial after the Second World War, specifically in response to the Nazi experimentations. That was a terrible, terrible period of human history. But what is consent? Well, to put it simply, a consent is an agent's authorization to be interfered with by another agent. In the clinical setting, it is necessary for a patient to authorize, either by means of a gesture, signature, or verbal consent, words, and so on, to authorize a proposed medical intervention. Healthcare in the modern context, because it is treated as a collaborative affair between provider and patient, informed consent becomes a very, very important ethical principle. So if the patient so chooses, she has the ability or the right to give what is called a valid refusal, right? Or to refuse a particular medical intervention. But in order for a decision to be autonomous, or in order for a patient to be able to give an informed consent, a patient must be entitled to all of the relevant information that pertains to the illness that is in question, as well as the diagnosis and prognosis. And secondly, patient also need to be made aware of the nature and the foreseeable results, consequences, benefits, risk, and probability of a success of any proposed treatment or intervention, as well as the alternatives that are on the table. Obviously, it is not feasible to tell a patient everything about the disease or to go into every bit of technical detail about the medical intervention. But it is important, however, to ensure that the patient has sufficient, or what's called sufficient information to make a judgment that is consistent with the patient's personal values. This is very important. Notice that it is a patient's personal values that is at stake here. So it is for this reason that providers do not usually make what is called quality of life judgments for the patients. Right? They do not get to decide whether a life is worth living or not, on behalf of for the person who is going to live that life. So, for instance, it would be morally problematic for a provider to judge for the patient that a life without legs is not worth living, for instance. In 1959, Jerry Canterbury underwent surgery to correct a disc rupture, but he was not informed that there might be a risk of falling out of bed. Sure enough, he falls out of bed and was paralyzed in his lower body. In an important court ruling in 1972, called Canterbury v. Spence, the court decided that respecting the autonomy of the patient means that as much information as a reasonable patient would want to know is necessary to fulfill the obligation of informed consent. This, of course, leads to the issue of competence, because if a patient happens to lack the mental capacity to understand the disclosures, right, the disclosed information, or the ability to make a decision about treatment, such as when someone is too young, a child, or suffering from a coma, it becomes difficult to respect a patient's autonomy in these cases. So some patients may even be, episodically competent, such as patients who are suffering from different degrees of dementia. So competence becomes a very important concept. So what is it? Well, competence designates a threshold of mental maturity and acuity that patients must meet in order to be able to make autonomous decisions about important matters concerning their health. Those who are competent, right, those who have this capacity are designated as having capacity or to be decisional. So there's a helpful scale called the sliding scale standard that helps providers to determine how they should protect patient autonomy in different cases. And it states that the degree of competence a patient must have to validly refuse treatment is directly proportional to the gravity of the consequences of refusal. Now, this means that a patient must demonstrate higher levels of mental lucidity in order to legitimately refuse treatment. That might lead to the avoidance of serious harm or death. Now, if a patient is refusing life-saving treatment in an emergency situation, the burden of proof for lucidity is even higher, say, than a patient who is simply refusing to take antibiotics for a minor infection. Now, when a situation is extremely dire and there's simply no time to seek consent, such as when a patient is suffering from a sudden heart attack, providers may, in these situations, treat the patient without any consent because it's just impossible to get consent. But there's also another form of paternalism that is more controversial. It's called therapeutic privilege. Now, therapeutic privilege is usually invoked only when disclosure of certain information might put the patient's health in serious jeopardy or danger, such as when an anxiety-prone patient who is in a very fragile state, medically speaking, that any disturbance, emotional or otherwise, might drastically change the outcome of the treatment or might even lead to death. So in these situations, providers might invoke therapeutic privilege. But these situations are actually quite rare, so the concept is still very controversial. Some other patients might also use their current decision-making capacity, right? Some people will have it now, but will expect to lose it at some point in the future. They can use that current capacity to plan for the future if they expect to lose decision-making capacity in the future. Now, this can be done in a number of different ways, and one of them is called surrogate decision-making. It is when a person who knows the patient, which in most cases is a next of kin, a family member, someone who knows the patient is appointed to make decision on behalf of the patient. There are complications with this, of course, since every surrogate may not have the best interest of the patient in mind, right? Surrogates could also have, say, for instance, a financial stake in the matter, right? Or even disagree with the patient, with the patient's personal values and desires, for instance. So the court and hospital ethics committees may sometimes be involved in these kinds of cases in order to defend the patient's interest against possible conflicts of interest. Another way of planning for the future takes the form of instruction advance directive. It is usually called the living will. These are instructions that can be given to the provider also through a proxy or someone who has the power of attorney. Advance directive, however, is not always seen to be binding in emergency situations. For instance, sometimes families challenge the advance directive by arguing that it is really outdated or that it doesn't apply for a particular situation. In these situations, providers are put in a very awkward situation whereby the family members and the patient may have disagreements, right? And there's no way to settle that disagreement. Sometimes it is due to the family's unwillingness, to sometimes let the patient go in situations where the patient is in an end of life care. But the hospital simply cannot determine whether this is true or not because the patient lacks decision making capacity. So some states decided to adopt what is called the Physician's Orders for Life-Sustaining Treatment, or POSLT, in order to give the patient something more authoritative or binding. Still, though, a patient cannot possibly anticipate all the possible contingencies that can happen in the medical context. So a POSLT doesn't always guarantee that the patient's desires will be followed by the provider. But in more difficult cases, patients might never had or never will have decision-making competence or capacity. This is a case of John Storer, who was cognitively disabled and dying of a bladder cancer. Though the patient's proxy, which in this case is his mother, wanted to refuse further very painful and life-prolonging treatment for her son's terminal condition, the court ruled against her decision on the basis that doing so constitutes harm for the patient. Yet, from the perspective of the mother, she is simply merely trying to end needless suffering. So this shows that there are some ambiguities when it comes to situations involving patients who are mentally disabled or who lack decision-making capacity. And it's difficult in these cases to actually judge what would be the value of the patient because they might not have any values, right? We don't know what the patient would want in this situation. So these situations present very difficult cases. Other difficult cases involve children, of course. Parents are usually the decision makers when it comes to medical interventions involving their children. However, because children and infants are unable to speak for themselves in a lot of cases and must rely on their parents for their care, there can sometimes be conflicts of interest between parents and children. So the hospital ethics committee and the court can also step in these situations, especially when it comes to decisions about whether or not to withdraw life support for a child, or even for a child to undergo certain kinds of very invasive surgical procedures, such as the Ashley treatment that you read about in the textbook. Well, so that is all I have for you today. I hope that you will enjoy this week's various case studies.